Hello, everyone. It's Anthony Bandia here, bringing you a search and seizure show. We haven't done this in a few months. These are kind of like a podcast style show where I'm going to answer a lot of questions. So this is great for those cops who are like on duty, want to expand their knowledge, but also pushing the black and white around and waiting for that next call for service. This is your jam, right? Just if you got to take a call, you pause it, reboot it back up. All right. So we're going to go through several questions. We're going to touch on Miranda, search instant to arrest, freezing homes, piggyback warrants. We have all kinds of stuff to get through. So as far as the time, this won't go any more than an hour, but we'll see how long it takes. So for me to explain each situation. All right. The question I want to answer is towing vehicles from curtilage. All right. I'm looking at my computer here. I got my little Buddha Gold Mac here. So this question comes from an officer in Ohio. The officer says, look, using your red, yellow, green diagram for curtilage, I'll explain that in a second. Can a vehicle be towed from a driveway for evidence from the yellow area without a warrant? This is going to be areas of curtilage. Also, what is your opinion on an inventory if the vehicle is being towed, right? Our policy allows inventories for tows, but I feel like it would be an intrusion. Instead, the inventory may be better from viewing things through the window and then seek a search warrant if you actually want to go into the vehicle. All right, so let's kind of give you some context here. So when I teach curtilage, which is a unfortunately, very confusing area of the law, I teach curtilage color codes, and this is what I mean. If the area is red, like constitutionally red, in my classes, I'll pull up a house and I'll put red around the backyard and so forth. That is an area that is curtilage, right? It's areas that are adjacent to a home and are associated with the home. And they're red because the general public should not be back there unless they have some kind of consent to be back there, right? They're invited over, the homeowner says, hey, come on in, to the backyard and so forth. So those are areas where cops, if they are going to be, they're going to need usually some form of like exigency, right? Emergency. Cops can be back there. There's all types of calls for service that allow cops to be back there, but you're going to have to justify it. Shooting calls, domestic violence calls, medical calls. I'm not saying that you can do this automatically with any of those calls, but the point is those are the type of calls that certainly get you into people's curtilage without violating their Fourth Amendment rights. Yellow is also curtilage. The porches, driveways, I think like right next to the home, right? And so forth. But these are areas where the general public could probably go in order to seek your cooperation or a knock and talk and so forth. There's kind of like an implied license. That's what the courts would say. There's an implied license for you to go onto that piece of curtilage in order to make contact with the homeowner. But you can't go too crazy there, right? That's why it's yellow. You got to be cautious. If you're bringing drug dogs up to the house, or you're banging on the door at 3 o'clock in the morning, waking these people up and calling it a knock and talk, that might be pushing it, right? Those are the type of things. All right. So green areas are areas that are either A, open fields, they're not protected by the Constitution, or they are not areas that the person has any interest in. All right. Generally speaking, when I have a single family home, right? Not apartments, not hotel rooms, but single family homes, and they have that driveway right next to their home that's adjacent to their home, or kind of a carport. Generally speaking, I consider that curtilage. I think that's a very safe place to be. Some courts may find that it's not curtilage, but if it's that single family home, this is my driveway, I get to park my car here. I think that is associated with the home, right? Enough to be protected to some degree. Now that is yellow. And so the question is, hey, if we see a stolen car, or this is a hit and run vehicle and we're going to take that vehicle with us, can we grab it, right? Can we take it with those facts alone? And I think the answer is no, right? Unless you had some other exception to come into the mix, like hot pursuit, the person pulled into their driveway as they were, fleeing police. That may change the outcome. But if you just drive by a house and you run a tag and the vehicle is stolen, and you have no consent, you have no exigency, you have no warrant, and you pull that car off of the curtilage, I think that's very problematic. And I don't teach it, right? I teach cops need something, consent, some kind of exigency, or a warrant. So the officer talked about also inventorying. Well, if your seizure is bad, your inventory is bad. If your seizure is good, your inventory is good. Now, one thing is, just so you know, let's say we seized the car because we thought that there was an illegal firearm inside the car. So we're going to search it for the illegal firearm. I don't use inventories to get evidence, right? Inventories are there to protect people's property. So if you have a community caretaking rationale, then that should be fine. But if at this point in time you don't have community caretaking, you shouldn't be going to that car just to also use the inventory to seize the evidence. A better exception would be the motor vehicle exception, which is if you have lawful custody of the car, and you have probable cause, then you can conduct a search. Now that doesn't work in every state. Pennsylvania, New Mexico, Washington, Oregon, these states, I think New Hampshire, these states require something more than just probable cause. All right, so there's your answer. If you're going to tow a vehicle from curtilage, you should have a reason to do so, not simply because you have probable cause. What is a good case to back up what I'm saying? Collins v. Virginia, U.S. Supreme Court, 2018. Next question. This question involves applying Gant to a backpack inside a vehicle. All right, Gant is referring to a case called Arizona versus Gant. I'll explain that in a second. Here are the facts. All right, this officer is from Texas. I stop a vehicle for a traffic violation. I see that the passenger is not wearing a seatbelt. All right, now we have probable cause for the passenger. I identify the passenger, discover that she also has a warrant. So far, so good. I detain her, and I see that she has property in the passenger seat with her. Let's assume that it's like not on her lap, but let's say she comes out of the car and her purse is like still inside the car. Now, due to Arizona versus Gant, I know that I can't take custody of the property that her express consents. If somebody gets arrested from a vehicle and the vehicle is not going to be towed, you can't go back into the vehicle and to do a search just because you arrested somebody from the vehicle. That is what Arizona versus Gant stands for. Now, Arizona versus Gant does, however, allow a limited search for evidence when there's reason to believe that evidence of the offense for which they are arrested will be found in the vehicle. In other words, if they are arrested for, let's say, possession of narcotics, and you have a reason to believe, not necessarily probable cause, but something lower, if you have reason to believe that more evidence of narcotics, that violation is inside the vehicle, then you can actually search that vehicle. Most states allow this. Some states do not. So, just be wary of your state law. So now we have this passenger who's arrested for a warrant. Is there going to be any evidence of a warrant inside that car? The answer is no. So we're not getting in the car under Gant. Okay. Now I asked the driver if the property is the passenger's. And he says yes. I said, okay, can I have it? The driver then gives me the bag and I take custody of it and make it part of her inventory. I do not ask if she wants to have it with her, right? But I assume that she wants to have her purse. I then conduct an inventory. Am I good? The answer is yes, right? So the officer did a good job here. He's asking, kind of confirms that the purse, is the passenger's. It is a valid, reasonable presumption, right, that a person would want their property, especially their intimate property, to be taken with them to jail. She also doesn't say, no, I don't want my property with me. So that appears to be consensual, that she's going to want her intimate property like her purse, a person's backpack, and so forth to be taken with them. I think we're good here. Not every court may agree with this, but if I was the judge, I'm going to find that this was a reasonable presumption and valid inventory. We go from there. Now, if the, anyway, we can change the fact, change the answer all day long. So there's the answer for that. All right? All right. Next question. All right. We're going to talk about, this question involves freezing and entering a third party's home in order to get an arrest warrant or a search warrant. All right. This question comes from an officer in Colorado. Officers are serving an arrest warrant and at the suspect's known address and at a third party's residence. Okay, so we have an arrest warrant. What does the arrest warrant give us the authority to do? Generally, it allows us to go and serve it at the fugitive's domicile, residence. Where do they live, right? We are allowed, as part of the arrest warrant, it comes with this authority to go into to their domicile to also effectuate the arrest. The only state that I'm aware of that does not allow this is Pennsylvania. In Pennsylvania, you would have to get an additional search warrant to search even their domicile. But every other state that I'm aware of allows you to also search the actual residence for them if you have a reason to believe that they're actually home. Now, if you don't think that they're home at the time, you should not be entering that home, right? Because why are you doing it? You're not taking them in custody. Where do we get this authority? A Supreme Court case called Payton versus New York. All right. So we go to the third party house, right? We knock on the door, and the third party either tells us, yeah, the fugitive is here, or we see the suspect, the fugitive, through the window. Now, I understand, the cop says, in some situations we can force entry. When can you force entry? When you have some form of exigency, right? Imminent escape, destruction of evidence, immediate or imminent harm to cops, somebody inside, or so forth. Something is pressing. Something is like, hey, guys, we don't have time to go chase paper on this. We got to go in. That's what the officer's talking about. Now, what if they don't have that? What about having the officers surround the residence while they go get a warrant? Right? Again, this is for a third-party home. Are we okay? Can we go into the suspect's or the third party's backyard, for example, to make sure this guy doesn't escape? And here's my answer. First of all, I don't have an exact case on this particular scenario, but I've thought about it many times, and here's my answer. You can go into the third party's home if you have some form of exigency. In other words, if you're just doing it like, yeah, we're going to get paper, we're going to go into the person's backyard as a matter of routine, well, the problem is you are intruding on the third party's right of privacy. And they have a right to keep the government out of their backyard without either some form of their consent, which they're not giving here, some kind of urgency, which you would have to articulate, or judicial approval. So if the officers are thinking, I have a right to, I'm not going to go into the home, but I'm just going to go into the backyard to make sure that the fugitive doesn't escape. And then I ask the officer, okay, why are you doing that? Like, what specific facts and circumstances do you have right now to lead you to believe that that fugitive is going to, escape before you come back with a piece of paper? And you say, well, I don't have anything specific, but it could happen. Then I would say to you, we have a few problems. Number one is you can't intrude on people's privacy, liberty, freedoms, rights with a what if, right? You can what if everything to death. What you need to do is, in order to intrude on people's privacy, liberty, freedoms, and so forth, is that you need to articulate some kind of probability. Anthony, if I am not in this backyard, the person will probably escape because of these reasons. Do you need a level of probability beyond a reasonable doubt? No. But do you need something that looks kind of like probable cause level? The answer is yes. Because in a case called Florida versus Jardines, the U.S. Supreme Court has stated that curtilage is protected, I should say, like the home itself, right? Well, the home is the most protected area under the Constitution. And when the U.S. Supreme Court is saying that the curtilage is similarly protected, then what they're telling you is that you better be careful, because if you're intruding into that space, you're going to have justification. And if all you have is, Your Honor, I do it as a matter of routine, you have a problem. Because you can't go into a home as a matter of routine. You would need some kind of consent, a recognized exception based on usually exigency, or a warrant. So there's your answer. Can you do it? If you have justification that you have some form of urgency. The guy has been fleeing and has been elusive for the last month. He's not submitting to the he's not going to submit to the warrant. You have reason to believe that given a chance he's going to bolt out that back door. Then I think you're fine. But the problem is, and this is why it matters, is if you go into that backyard and something bad happens with the homeowner, right? You get into a fight. He tells you to get off his land. You say no, things happen, force is used, and he then sues you. And you go to court, and you start throwing out the whole, I can do it as a matter of routine, Your Honor, type of language. You're probably on shaky ground. That's why it matters. All right. This is a good one. So our next question is intentionally placing two suspects in a patrol car together a violation of Miranda? I like this question. This comes from an officer in South Dakota. All right. First of all, he's an avid watcher and listener of the channel, and I appreciate that. All right. I was dispatched to a call of multiple gunshots and arrived on scene almost immediately. Now, the multiple callers did not give a description of the people, but, look, it's probably, let's just imagine, it doesn't describe this, but let's imagine it's kind of late at night or not a lot of people around. They certainly have heard gunshots, and people in South Dakota, like everybody owns a firearm. They know what a gunshot sounds like, right? So the cop then sees two people walking away from this area where the gunshots are heard. Now, he's going to make a contact with them, probably going to try to make a consensual encounter, which is good, right? We don't know yet if we can make a detention. We're very close, to say the least, if not there. But let's just say the officer wants to make a consensual encounter. As he's approaching these guys, he sees one of them bend down as if like maybe tying his shoe, and then get back up and then starts walking again. The officer then contacts them. He ends up actually patting them down. So now we have a detention that turned into a detention. Let's just, for argument's sake, let's presume that this is all good to go, and I think it's going to be. Well, they denied any involvement, in the firearms violations. The officer then goes over to that area where one of them knelt down, and what does he find? He finds a sawed-off rifle and a handgun, right, in a window well. So good. This is great evidence that these are our shooters, right? So then they're handcuffed, they're arrested. All right. Well, I should say at least the officer's using detain, but probably in all reality, this is an arrest under the Constitution. All right. So then backup officers are going to put them into two different vehicles, right? And the officer gets over the radio and pretty much, probably into the earpiece of one of the officers, hey, no. Don't put them in separate cars. Put them in the same car so they can talk. Well, dispatch wrote this down, in the CAD log, which is fine, right? The question is this a violation of Miranda? Let's assume, for argument's sake, that they also, just to throw this in there to make sure we're really clear on this, that they even invoked Miranda. They said, I want a lawyer. I don't want to talk, right? And we still put them into the back of the car. Well, what is in that car? A recording device. Okay. Is this a violation of Miranda? Is this going to cause their testimony, if they talk, and to be thrown out? And here's the answer: no. This is not an illegal tactic. It's not unconstitutional. It's not unethical. Can a defense attorney bring it up and try to make you feel bad, or try to say, hey, you violated the right? Certainly. But at the end of the day, is this a lawful tactic? The answer is absolutely yes. Let's look at why. Miranda has to do with police interrogation. Okay, so Miranda applies under when these three circumstances exist at the same time, then you need Miranda. Fletzy calls us the three C's: cops, questioning, and custody, right? Questioning obviously is a Q, but it sounds like a C as well. So the three C's: cops, questioning, and custody. Cops, it has to be like a known officer. It's the police doing it. Are the police interrogating these guys while in the back of the police car? The answer is no, right? It's each other talking to themselves. Are they in custody? So we have cops. Cops are not involved. Are they questioning them? No. And are they in custody? Yes. So you only have one out of the three C's. Miranda does not apply under these particular circumstances. Also, we know that a person does not have a reasonable expectation of privacy in the back of a police car. So while they're back there talking about their crime, and the video camera captures the audio or the video of that, can that be used against them in court? The answer is yes, because it does not violate the Fourth Amendment. So this officer actually, in my view, did well, right? By actually telling his officers, hey, look, put them in the back of the same car, so hopefully they will talk and we can use that evidence against them. There's nothing unethical about that, nothing illegal, and so forth, all right? So great question. I know it sounds kind of, maybe, to some people it sounds, illegal in some way. It's not. It's actually a valid tactic. All right, there you go. Are you learning something? Hopefully you're getting something out of this. All right, let's go to the next question. All right. This is we have another Miranda question. The officer says, this officer is in California. Can a partner of mine ask a suspect questions if I'm the one that got the Miranda waiver? So look, Anthony, I read Miranda, right? I got the waiver. He says he'll speak to me during a detention. Can any of my partners ask questions of the suspect during the course of this detention? And the answer is yes. Miranda is required when you have the three C's: cops, questioning, and custody, right? Questioning is a Q, but it sounds like a C. This comes from Fletzy. So do we have cops? Yes. Do we have questioning? Yes. Do we have custody? Well, we have arrest-like custody when the officer's talking about these detentions. So yes, we have Miranda, but nothing in Miranda, nothing in any case law since Miranda came out, requires that every individual officer get their own Miranda waiver. The waiver is valid for all law enforcement, at the very least, that are working on that case. So if I'm on the case and I come up to the guy and say, hey, so tell me what happened again? I know you told my partner, but tell me. I can absolutely do that. Can another officer from a different agency and totally different crime come into the interview room and say, hey, since you're here, can I talk to you too? And ask some questions? The answer is yeah, because Miranda is not crime specific. Now, if you wait a day or so and another agency comes into grabs this guy out of the jail cell and wants to talk to him, should you get a fresh waiver? The answer is yes. But the point is, on scene, we are good to go. Great question. I hope this clears it up. You are good to go. All right, let's go to another question. All right, so this question comes from an officer in Las Vegas. So Las Vegas, Nevada. Okay, is a search warrant required for a shooting scene inside a home? Let's look at the facts. All right, Anthony, the scenario is that you get called to a domestic dispute. The reporting party advised their sibling fired off 2 rounds inside the home. Upon arrival, you have everyone exit the home and you conduct a sweep of the residence. This is totally lawful, right? You are looking for perpetrators and victims. That's why you're in there. It's a public safety rationale. While in the home, no blood, bodies, or suspects were located. You do see shell casings in a bullet hole in the wall. So that's plain view. After everything is settled down, the homeowner is agitated, right? And states that they don't want you there anymore and to leave their home. You establish the homeowner is not a suspect and is actually the victim of assault with a deadly weapon. The suspect was apprehended down the street in a vehicle they fled in. My question is do you now have to exit the residence and do a premise freeze for a warrant? Or, due to the fact that you see plain view evidence of a crime had occurred inside the shell casings, does that prevent you from, processing the crime scene? What is the case law, if any, behind this? All right, I definitely have your answer. Okay, so, all right, coffee time. Let's go through this. So first of all, we're lawfully inside the home all day long. I already explained that. The second thing is the plain view. While you're sweeping for the people, you saw plain view evidence. So far, so good. Now, at the point where the homeowner who has standing in the home, right, they can tell you, hey, you no longer have my consent to be in my home. At that point, you are not allowed to process a crime scene without a warrant or some kind of exigency. Like, let's say that you had evidence that is going to be destroyed, manipulated somehow before you get that warrant. You have to give me the facts. But yeah, you can certainly retrieve that evidence in the meantime. But here, we don't have anything like that. So you don't have consent, you don't have any form of exigency, and you don't have a warrant. But you are still in the home. The one thing that you would be allowed to do in this home is grab the shell casings. Because they're in plain view. There's nothing, since you're already lawfully in the home, nothing prevents you from grabbing and going. But if you wanted to recover that bullet from the wall, or you wanted to really do some crime scene style photographs, you need a warrant for that. Because the hole is plain view, but the bullet is not, right? It's in the wall somewhere, and you're going to want to recover that. Also, the crime scene photographs, taking a photo, is one thing, but crime scene photos give the air of processing crime scenes. And you can't do that, right? You can't do that, even despite the fact that you're in the home. So the case here is Mincy versus Arizona, 1976 or something like that. So it's been around for a very long time, and the U.S. Supreme Court has held that even if you have a serious crime, and Mincy was a murder of a police officer, even if you have a serious crime, you cannot process a crime scene unless you have, generally speaking, judicial pre-approval or somebody's consent. Oftentimes you will have consent because people are the victim of crimes and they want you to find evidence of their perpetrator. Here, the perpetrator is a family member. Also, we have a problem. The family member likely has standing inside the home since I think they live there. And if you process that crime scene thinking to yourself, oh, I know the victim doesn't want me here, but we're not going to charge them with the crime. Don't forget, who can come in and try to suppress the evidence? The suspect, because the suspect has standing inside the home. Their rights are being implicated while you are processing a crime scene. So in this case, you wouldn't do it, even if quite frankly, even if the perpetrator was a random a stranger or even a friend that has no standing. Are you really going to process a crime scene when you have a victim there yelling at you to get out of their home? No, we're not doing that. If that's the case, we are going to remove the people from the home. We're going to lock it down and we're going to get a warrant. And I think that might be the other, yes, that also has the, I think the officer wanted to know about that too, about freezing the home. Yeah, exactly. So what we can do here, without a doubt, that case is Illinois versus MacArthur, okay? That if you're already in the home, you're allowed to freeze it. You're allowed to kind of maintain status quo. Whether that is, hey, look, allowing the person to sit on the couch while the warrant is gotten, or physically removing them from the residence because it's not practical to keep them inside the residence and so forth. Either way, it's up to you, okay? Use good judgment, have a reason for what you're doing, but the law is in your favor. All right? I hope this has helped. If you're liking this Search and Seizure show, you're going to do me a favor, hit the like button. If you're listening onto podcasts, hit the like button as well. All right, let's go to another question. All right, guys, If you're just joining us, by the way, my name is Anthony Bandiero. This is a search and seizure show. I used to do these frequently during COVID, and now I kind of do one-offs. But when I get a lot of questions, I like to just do them as a show so I can kind of get all the answers out. All right. This question comes from an officer in Oklahoma, and it's about piggyback search warrants. All right, let me give you the context. 2 people live at a residence. Police execute a search warrant in the daytime for child pornography, right? They're looking for cell phones, computers, etc. During the search, they find guns. The suspect is a convicted felon. Now, the police take the suspect to jail, and the roommate is asked to remain outside the residence since a new warrant is going to be gotten for the more firearm evidence, right? The police exit the residence at the conclusion of the original search warrant, but the police maintain watch of the residence, thus locking it down while another search warrant is gotten. This sounds like the previous question, but of course this is a little bit different, so we're going to still go through this. Okay. The roommate is still waiting outside once the police get their new search warrant. Do we need to notify the roommate who's outside the home for knock and announce? And, right, so knock and announce is the Fourth Amendment requirement that you announce your presence, your authority and purpose before entering a home to serve a search warrant. That gives them time to come to the door, peacefully submit to the search warrant, and so forth, right, before breaking down the person's door. Do we need to do knock and announce? The answer is no. Knock and announce is not required under these circumstances because the person, that we know that there's nobody inside the home. In other words, knocking and announcing under these terms would be futile. The other thing is the occupant, the roommate, knows what's going on. I mean, they're outside the home waiting. I'm sure police officers have told them, hey, look, we're getting another search warrant. But as far as knock and announce goes, there is no obligation at all to pound on that door again, say police, search warrant, wait a reasonable time, and then enter. Because it's locked down, police could literally just walk right into that home, start serving the next warrant. All right? All right, there's your answer. All right. Let's go on to another question. All right, this question comes from an officer in Las Vegas, and the officer is asking about identifying passengers due to no licensed driver. All right. So, I conduct a traffic stop on a vehicle for a moving violation. And upon making contact with the driver, they state they don't have a valid driver's license. The passenger also says they don't have a valid driver's license. Per our policy, we can tow that vehicle because there's no licensed drivers in the vehicle. Okay. Now, the cop, this is where it gets a little, takes a turn. In order to confirm, to know for sure that there is no licensed driver, hold on, got a cat that jumped up on the, okay. In order to confirm that there is no licensed driver in the vehicle, would it be considered extending the stop in order to demand or make the passenger identify themselves to confirm that they have no license? Can we do that? And the answer is no, right? We are not going to be able to demand, further detain a passenger to confirm that they're telling us the truth about no licensed driver. If they say they don't have a license, it's a no license, right? We treat it as if they have no license and we go on from there. If that means that the car gets towed, then the car gets towed, right? If the driver is all mad because he knows that his friend has a license, then they can take that up between themselves. And, maybe the passenger says, okay, I changed my mind. Here's my license. I don't know. But the point is there is no lawful authority in Nevada or anywhere to order a passenger to identify themselves to make sure they have a license. And what is going to happen if they refuse to identify, right? What's going to happen if they refuse to not have a license, to show you that prove they have no license? We're going to arrest them, charge them for the obstruction. There is no requirement. If they didn't have their seatbelt on or they were involved in other criminal activity, that totally changes the answer. So there's your answer. All right? All right, let's go to another one. All right. This question comes from an officer in Ohio. So, can officers enter a home for a civil standby if one party allows it, but the other expressly prohibits it? Good question. So, officers go to a home at the request of a party that is moving out. A female who has resided at the house for years is moving out, and there's even a moving truck in the street being loaded. And the male homeowner is being very difficult, right? The female grants officers consent to come into the home, but the male expressly prohibits it. He's like, you got to stay out. Do not come into my home. Can the officer still go inside under the guise of pure peacekeeping or civil standby, right? To ensure no one is assaulted, threatened, etc. There's no intent to search or arrest. It's to protect the parties. Okay, the answer I think is going to be no, not under these facts. So what's going on here is a few cases. Okay, let's talk first about Georgia versus Randolph, U.S. Supreme Court. In that case, the Supreme Court has held that when two occupants disagree as to whether police can enter the home, then the non-consenting party is going to win, right? So if the wife says come in and the husband says get out, the answer is get out. We're also going to talk about a case called Brigham Young. It's I'm forgetting if you look up Brigham Young, City of Brigham Young Supreme Court case, but it's a case where the Supreme Court upheld, entering a home for emergencies, right, to protect somebody from imminent harm. Well, look, we can certainly, when it comes to these civil standbys, right, a lot of times you're going to have exigency, some kind of urgency. You're going to have a person who has committed domestic abuse against this person, maybe a recent arrest. Now they're out, they're back at the home. You're going to have the victim telling you, this person is physically abusive to me. They have guns. They pulled out a knife. You're going to have people saying this stuff, right? And if you have people saying that stuff, that absolutely, if you have reason to believe that this person, while moving out, could be in imminent or immediate, harm, be in harm's way, you are absolutely allowed to keep the peace, and so that he or she is protected from violence. However, and you may not agree with this, right? But if the person is moving out because they just don't get along, and the evidence indicates that this is just a verbal, right? That they just don't like each other, or they yell at each other, whatever, that is probably not going to be enough to prove to the court that there is some kind of imminent or immediate risk of harm, right? So what can cops do? Stand at the door, right? If the male half is just sitting on the couch, being difficult, saying things that are, crass and so forth. Look, it is what it is, right? Stand at the door, look for those signs that violence, may erupt, and then you go in. But until that happens, don't go into the home, right? Because I don't think you're allowed to go into the home. I would not go into the home. I think that Georgia versus Randolph is a case on point, and I think that the message is clear. You need exigency to override a person's lack of consent. All right, let's continue. All right, this next one comes from an officer also in Nevada. All right, the question is this. Is it illegal to search a person's bag to find identification if they are being trespassed from property? All right, very common question. An officer was dispatched to a building where a person was camped out in front of the main door. So they're on university property. This is a university officer, university property. They are trespassing. That's not lawful camping, right? The officer asked the subject to leave the area, but the subject refused to move and refused to give her name so the officer can read her the trespass warning. The subject had a purse, and the officer went in the purse to look for identification and found an ID card. The subject was actually ultimately arrested for trespassing. The officer was reprimanded by his sergeant for an illegal search of the purse before an arrest was made. What do you think? I think that the officer is legal here. Okay, so let me explain to you what's going on. Number one is, the one thing I want to talk about is most trespass laws in the United States have a requirement that the person first be given notice to move on. And if they refuse, then that is when it becomes trespassing. Or they knew before even entering the property that they were trespassing, right? So for example, there's no trespassing signs in a gate and people are, climbing over a fence. Right there in most states, that is instantly a violation of trespassing because they know or should know that they are not welcome onto that property, right? Okay. And the reason I bring that up is because generally speaking, if people are, at a piece of private property and they're being told by somebody that owns the property, hey, I want you to leave. And they leave, but the police also show up in the meantime. Do we have a legal right to force those people to identify themselves? And the answer is no, in my book, if your law is written in a way that requires the refusal first, right? Unless they have notice, and most laws are. Because here's the problem. They're not violating the law. If I go to Walmart, no, I'm sorry. I'm a little more bougie than that. If I go to Target and I'm shopping there, and let's say I'm a concealed carry holder like many of you, right? So let's say I'm trying to grab the box of Cheerios, and somebody sees I flag, right? I got my belly shirt on, and the tip of the gun is seen. Somebody sees the gun and goes to the manager. And while this is all going down, somebody calls the cops, right? And the manager then, let's say I'm, now checking out, and the police and the manager come over to me and say, hey, we know you have a firearm, and let's say I have a concealed carry holder and all this kind of stuff, and I show my ID. And, look, I guess that kind of ruins the thing because you probably have my identification now. But anyway, the point is I'm doing nothing wrong besides, look, I'm not even gonna cooperate. Let's say I'm in a state where concealed carry is presumptively lawful, right? Let's say Texas, where it's constitutional carry. And the manager says, I want you out of here. We don't like firearms here. And I'm like, okay, fine. I put my box of Cheerios down. I said, I'm out of here. Can the cop detain me and make sure that A, I'm not a felon, or B, just kind of get my information? The answer is no, because I'm not violating the law. Having the firearm under those circumstances was not illegal. I did not brandish it to anybody. It was just a accidental observation and so forth. So that's what's kind of going on here. I'm just kind of going on in the background. I want to let you know. Now back to the story at hand. She is trespassing. So the fact that the officer searched her purse before formally arresting her is actually legally irrelevant. That case is Kentucky versus Rawling, and it might be Rawlings v. Kentucky, but you'll find it either way. U.S. Supreme Court case. In fact, actually, I have it right here. Sorry, let me pull it up. It's Rawlings v. Kentucky, 1980. So, the court says, we do not believe it is particularly important that the search of the person, right, preceded the arrest rather than vice versa. So, Rawlings v. Kentucky is your case. It doesn't matter. This is not illegal. Now, the other thing, too, is even if there was no intent to arrest, we just want to actually issue a citation. Can we perform a limited search that's targeted to get her ID so we can issue the citation? The answer also is yes, right? Well, I'm not going to do a full search into arresting this person because we're not going to transport them, but do we also have the authority to at least identify them in order to issue our citation if we have lawful, if we have a citable offense? The answer is also yes. So either way, whether there's an arrest or no arrest, I believe that the officer is good here. All right? All right. So far, so good. Are you guys finding value on this? We've been at it for 45 minutes. Let me answer a couple more questions. Again, there's a lot of questions here. All right. So this officer is from Pennsylvania. Can homicide evidence be suppressed because of an unlawful search and seizure? All right, let's check it out. A police officer pulls over an out-of-state registered Ford vehicle, right, that turns into a parking lot and at 2 a.m. The officer believes that this is suspicious and performs a traffic stop. The driver is cooperative, gives all the proper identification, everything comes back valid. But then the officer then sees that the driver has multiple unopened bags of prescription medication that's prescribed to the male driver in plain view. And the officer believes that a drug deal is going on. No other indication other than a hunch. Let's just say that legally we are at a hunch. The court believes that there's a hunch. The officer then orders the male driver out of the car, does a search of the vehicle thinking he has probable cause, and he also didn't even ask the driver for consent either. So we have no consent, and let's say we have no probable cause because this was based on a hunch. Upon searching the vehicle, the officer found a dead woman in the trunk. I believe this is a true story. This is not a hypo. With the apparent murder weapon also in the trunk, a knife. Obviously, the guy gets arrested. Based on this, will the evidence be thrown out? All right, so look. The answer is yes. Yes, the evidence will be thrown out if the court finds that that the search was without probable cause, right? These are the exclusionary rule is heartless. It's cold. It's mean. It's tragic, right? There have been plenty of cases that have been decided over the last 100 or so years where very significant evidence has been suppressed because an officer has messed up, including dead children. So, is it possible that the dead person, the victim here, right, this murder evidence will be suppressed? And the answer is yes, if the court finds that the cop was in the trunk for no reason, no lawful reason. At the same time, I will tell you that in reality, courts will bend over backwards to make sure that they got it right. They will look at everything that the officer articulated and also maybe ask the officer things that he or she did not articulate. In other words, yeah, maybe looking at this, the officer is like, yeah, I guess I only had a hunch. Sometimes the courts will say, well, actually, these other facts, you didn't articulate them, but they also are relevant. So we're going to find that this was a valid probable cause search. Therefore, the evidence was not the fruit of the poisonous tree. However, if they cannot analyze the case, after analyzing it, they cannot come up with a probable cause and there was no consent, then they're going to suppress the evidence. And that is the tragic truth and reality of the exclusionary rule. All right, there's your case. The other thing, since we're on the point, this case also from my officer in Pennsylvania, Pennsylvania has a case called Alexander. Alexander requires exigency to actually search a car under the motor vehicle exception. So if this is a state case, right, if this is not going federal, because the feds don't care about this rule, but if this is a state case and the officer, let's say the officer did have probable cause, but did not have exigency or consent, that might be a problem under Alexander. All right? All right, guys, let's do another question. This question comes from an officer in California. Can police make a warrantless search of the vehicle when a reporting party, an RP, saw the driver whisking a gun, or, whisking, right? It's kind of like whisking like mashed potatoes. All right. Reporting party called 911, stated he was passed that he passed a parked vehicle and that he saw the driver waving around this gun inside the vehicle. The RP also described the firearm with a lot of detail. So, now police make contact with that person. When they make contact, they do not see the gun in plain view. Can the police search the vehicle for the firearm? All right. So the answer is probably yes. Okay, let's go through this, right? Do the police have probable cause that a crime is being committed inside that vehicle? Well, we also have to look at where we're talking about here. We're talking about a place called California. California is in competition with New Jersey and New York to be the most anti-gun place on the planet Earth, right? So that is going to come in. I mean, first of all, whisking a gun around sounds like there might be a mental issue, but having a gun in plain view, if somebody sees a gun in plain view in Texas and the cops in Texas get called, they're going to laugh at the caller and say, sir, ma'am, this is Texas, okay? Now, when you come and become a resident of Texas, we give you a free gun, okay? So call us when something is a little bit more indicative of criminal activity. In California, they do the opposite. Gun, send out the SWAT team. So that's the first thing. So just kind of realize like having a gun and like whipping around, especially in a place like California, is indicative of criminal activity, right? They're not going to permit that kind of stuff. There's an assumption there that you're not really lawfully carrying. I think that's kind of like, now is that going to change with a Supreme Court case called Bruin that actually upholds the Second Amendment for every state and people have a right to carry outside the home? The answer is yes. But right now, as I'm making this webinar, the laws are very strict in California about firearms. The next thing is, can we take this reporting party at face value? The answer is yes. The presumption is this: witnesses who are not involved in crimes are presumed to be reliable, right? In other words, you can trust them. The next thing you have to connect, though, is, all right, fine, you can trust them that they are telling you what they believe is true. However, what are they telling you that is indicative of criminal activity? Is having a gun in and of itself in a vehicle a crime, out in the open and where people can see, is that a crime in California? I don't think so, strictly speaking, right? I don't see brandishing here because the person didn't point at somebody. There are concealed weapon holders in California. But what I see here is at the very least, I see reasonable suspicion of criminal activity. And the reason I say that is because of the manner that the firearm is being held, right? Controlled. Sane, prudent, sober, concealed weapons holders do not take out their gun and whip it around in a vehicle, right? Unless it's a really good country song or maybe a rap song or something. But generally speaking, they're not doing that. So are the police going to make contact in this scenario? I absolutely think they should. Can they detain that guy? Absolutely, right? Absolutely. You're going to be able to detain this person, even in Texas, to find out why are you handling the firearm in that manner? What's going on? Again, are you intoxicated? It's just not safe handling, right? So we're going to make sure that the person is mentally fit right now to possess that firearm. I guess that could be a charged type of term, but anyway, just to make sure that everything's okay. We make contact. We get him out of the car. We pat him down. He does not have the firearm on him. Can we get into the car at the very least and search it for weapons, do a protective sweep, and secure that weapon? The answer is yes, of the passenger compartment. Where can that person access that weapon? We then find the weapon, we secure it, we then do our investigation, we find out what's going on with him. If he's legal and everything else is fine, we let him go. If he's not, then we go from there. That's what I would do. So do you have probable cause? Do you have reasonable suspicion? I think you have reasonable suspicion in every state under these facts. All right? All right. We are going to do one more. Okay? Let's see. All right. We're going to do one more. This one is an officer from Tennessee. And the question is, do drivers have to display a driver's license at a DUI checkpoint? So, let me read you the background here. All right. If we have a DUI checkpoint, right, does this also allow the police to ask for a driver's license too? I actually have seen only one case directly, on this issue. And it's a recent case from 2022. It's out of the Ninth Circuit out of California. And it upheld an officer's also checking the driver's license of these people coming through the DUI checkpoint. The case is Demarest versus the city of Vallejo. I'm going to give you the citation. So you ready? 44 F fourth, that's federal fourth, that's like their binders, right? 44 F fourth 1209. 44 F fourth 1209, Ninth Circuit, 2022. The Ninth Circuit held that it was reasonable to also, it's in line of public safety, right? Not only are we trying to get drunk drivers off the road, but since we have you stopped, let's also make sure that you're licensed to drive. It's highway safety minded. It's not for general criminal activity, which is prohibited. You can't, start interviewing people about narcotics and so forth, but unless you had reason to believe that they could be under influence. But the Ninth Circuit upheld it. I think that's the right answer. It's part of the temporary seizure, and I think you're fine. All right, guys. Hey, look, that's what I have for you. We've pretty much been at this for almost an hour. As I said, we had a lot of questions. This is one of these webinars where I can see you listening to it maybe multiple times, right, to kind of catch a lot of stuff that I said. Here's the other thing I want you to do for me. I have not made one of these long versions in a long time. I usually make these one-offs, right? Do you like these too? Do you want me to make more of these? Hell, if you like them, I can try to make them once a week, just as an extra kind of bonus for all the other questions that I answer. But you need to tell me if these are valuable to you, because I'm not looking to waste somebody's time. And also, quite frankly, I have a lot of stuff to do as well. So if it's not wasting your time, it's not wasting my time. Hit me up in the comments below. Hit like, share with your friends. But if this thing gets only like 15 views, then I know it's probably not worth people's time. All right? All right. Guys, thank you so much. Stay safe out there. If you have more questions, give them to search bluetogold.com @show. All right?